Okay, good afternoon, everyone, and welcome to the first part of our Higher Education Data Privacy and Cybersecurity webinar series. This six-part webinar series focuses on the intersection of higher education and data privacy and cybersecurity. Today's webinar will start with a primer in data privacy and cybersecurity to help identify applicable data privacy and cybersecurity challenges for higher education institutions. The subsequent webinars that we will have in this six-part series will be tailored to specific higher education institution areas, departments, or risks relating to data privacy and cybersecurity. I would like to introduce our speakers today. First, we have Barbara Lee, who's of counsel in our New York City office. Barbara provides higher education clients with legal counsel in all aspects of education law, including academic and student affairs, faculty tenure and promotion, diversity and hiring initiatives, governance issues, and sexual harassment issues. Prior to joining Bond, Barbara was Senior Vice President for Academic Affairs at Rutgers University, where she continues as a Distinguished Professor of Human Resource Management. She is a former director of the National Association of College and University Attorneys, known as NACUA, and is a regular speaker for the organization. And is currently editor of NACUA's Journal of College and University Law. She frequently serves as an expert for her vast experience in faculty discipline matters and investigation across the country, and especially as it relates to discrimination. In addition to her academic experience, Barbara is also the former chair of the New Jersey Bar Association's Higher Education Committee. Thanks so much for joining us today, Barbara. Shannon Knapp, a data privacy and cybersecurity associate, sits in the Syracuse office for Bond, Schoeneck King. Shannon holds a certificate as a certified information privacy professional, specializing in privacy law in the United States. This certification is issued by the International Association of Privacy Professionals, the largest global information privacy community for professionals who have developed their careers managing data privacy. Shannon counsels clients on various data privacy and cybersecurity matters, including regimes like the California Consumer Privacy Act, the European Union's General Data Protection Regulation, China's Personal Information Protection Law, the Children's Online Privacy Protection Act, and the FTC's enforcement actions. Shannon also has experience in data breach response and reporting via the New York SHIELD Act. And finally, my name is Amber Lawyer. I sit in the Syracuse office as well with Shannon. I am deputy chair of the firm's data privacy and cybersecurity practice. I am CIP certified like Shannon in European and US data privacy law, and I advise higher ed clients on privacy compliance, data breach response, and technology transactions. Thank you all so much for attending our webinar today. At the conclusion, please fill out our survey. We are so excited to welcome you to the program. Next slide, Shannon. Okay, so let's get started. As an overview of what we're trying to accomplish today, as I said before, this is really supposed to be a primer to set the stage for the webinar series. So we're going to talk about cybersecurity and data privacy challenges that higher education institutions face, recognizing that cyber and data privacy issues have really come to the forefront in the recent years and are top tier risks for higher education institutions. We'll talk about the applicable law, so the legal landscape that affects higher education institutions in relation to data privacy and cybersecurity. And then we'll talk about the current and future data privacy and security risks that higher education institutions face. You'll see below there is a Q&A chat box. Please feel free to submit questions throughout the program. If we can't answer them live and in time, we will follow up after the presentation. Okay, next slide, please. Barbara, I think this is you.
I think it is. You know, when higher education leaders think about risks to data privacy or the impact of ransomware attacks, I think they tend to think about student or employees' personal data, and that's certainly an important risk area. But as you can see, we put together a list of 22 different areas of risk for higher education institutions, and there are probably more than 22. That's 22 is certainly plenty to worry about, but depending on your college or university and what it does and the kind of data it collects, you may have additional areas of risk. Some of these are pretty obvious. General counsel's office records, for example, admissions, student data with social security number, date of birth, notes on admission file, that sort of thing. Student health records are also an obvious area of concern, both under FERPA and perhaps under HIPAA, depending on which of those two federal laws your student health area falls under. But how about institutional research? Do you collect confidential survey data from your students or from your faculty or other employees about climate or other issues? And you may not want that to be exposed publicly in a data breach. The credit union, the university where I teach, Rutgers, has its own credit union, which means it's subject to some of the financial regulation of the federal government. Mortgage applications, salary information, credit information, social security numbers. If I ran the credit union, I don't know that I would sleep at night with all of those concerns. Athletics may be something that we don't think much about with respect to a data breach, but the students' grades are housed in the athletics department as well as in the registrar's office. Any discipline they're subjected to, and perhaps name, image, and likeness information. So again, that is something that could be exposed in a data breach or ransomware attack. So study abroad, this is something that we have to think about with respect to the international data security laws that Shannon and Amber are going to talk about. So I'm going to stop with this list of horribles right now and turn it back to the next slide, please.
All right, so thank you for that, Barbara. That's like a great overview of all the risks of higher education. So we thought we'd take a quick step back and kind of go over some of the basics. So one of the first basics that we always like to discuss is the difference between data privacy and cybersecurity. They're very related topics or concerns, but they are technically different as well. So data privacy has more to do with personal privacy or keeping your own information private, and using it only for the intended purposes. This is something you're going to kind of hear us talk about. It's a theme throughout a lot of these privacy laws that we're going to discuss in the next couple of slides. So it's definitely a little bit more about keeping it private and protecting it and using the data as the owner wants it to be used. Whereas cybersecurity is a broader topic and has more to do with protecting data through appropriate administrative, technical, and physical safeguards. And so this has more to do with the protection of data, and it doesn't necessarily have to do with just personal information. It also has to do with other information that Barbara was talking about as well, confidential information, intellectual property, things that you just don't want to be out in the world, on the internet, things like that. And so although interrelated topics, they do have their differences. Data privacy is really on the rise and has a lot of new consumer privacy laws. And cybersecurity is somewhat regulated through laws, especially like in the financial sector, but it usually is up a little bit more to discretion in that respect. So some of the top risks for higher education institutions, a lot of these are also interrelated topics. As you see, data breach is the top one that we're listing. The risk of a data breach is very high for higher education institutions, just given the amount of data collected by institutions and how it's housed. And the biggest risk with this is usually phishing or ransomware attacks. And according to the 2022 Verizon Data Breach Investigation Report, which is one of the top reports for data breach investigation, there's been a dramatic increase in ransomware attacks on higher education institutions. And researchers found that there was an over 30% of breaches in the sector were attributable to ransomware. And so for those of you who don't know, ransomware is when a bad actor comes in and basically shuts down your entire system and demands a ransom payment to be able to recover your data or have your system come back live or something like that. Whereas phishing is what you think about when you get like a junk email that might contain a link with malicious code or something like that. Vendor data breaches is also a big risk. This is something that Amber and Phil will talk about more in the next presentation in a couple of weeks, but we're just going to touch on it a little bit here. vendors are housing your data. If you're using like CRM systems or things like that, they're housing a lot of data. And if they have a data breach or like Blackbot, things like that, then you might also have issues with a data breach through not your own system, but your vendor system, which is why vendor contract review is so important and due diligence. Outdated technology, a lot of higher education institutions have legacy systems or haven't updated necessarily in accordance with the most recent standards for cybersecurity, and this can obviously increase the likelihood of experiencing a data breach as well. Then lastly, non-compliance with privacy laws. Because higher education institutions have students from all over the place, all over the world, many different states, and also many different types of data, there's a number of privacy laws that higher education institutions are subject to, and there's risk of enforcement mechanisms, fines, things like that, if there is non-compliance with privacy laws. So there's a lot of challenges for higher education institutions and threats to higher education institutions, which I've kind of already touched on, but this is just kind of breaking it down a little bit further. So on the data privacy compliance side of things, there's a global array of privacy laws that can apply to higher education institutions, both at the federal level, the state level, and also the international level. And then there's also a bunch of legal obligations and rights that individuals have around their data and that higher education institutions are expected to comply with. This includes how you collect the data, how you retain it, how you use it, having affirmative safeguards in place, respecting the rights of individuals if they make a request concerning their information, and also making sure you're keeping up with personnel training and other training requirements. And on the cybersecurity side of things, there's cybersecurity mandates and applicable laws, such as like GLBA safeguards, which we'll discuss. There's a number of cyber threats. I've already touched on ransomware and phishing, malware, which is essentially a type of virus that can infect a system. And then the amount of valuable data, we can't reiterate this enough. Higher education institutions are such threats because of the sheer volume and type of data that's being collected by these institutions. So it makes it a prime target by bad actors. And lastly, which is a unique problem to higher education institutions, is higher education institutions are generally decentralized, meaning that you have personal data stored in a number of different ways. Barbara touched on this when she spoke about it. You have data in athletics, you have it in admissions, you have it in financial aid, you have it in the alumni relations. It's all over the place, marketing. And so you have data in so many different spots. It's so decentralized. One, is hard to keep track of, and two, making sure that each of these different pockets have the adequate safeguards in place and are following the laws as a unique challenge for higher education institutions. So now we're going to preview our data privacy and cybersecurity laws that apply to higher education.
So it may be that you didn't expect to be thinking about FERPA today, but we just want to remind you that FERPA is relevant to data security, clearly. You're all familiar with FERPA, so I'm not going to spend much time talking about it because you could probably do that part of the talk for me. Fortunately, as you know, the Supreme Court has ruled that there is no private right of action under FERPA. So the subject of a data breach, a faculty member, a student, or several of them, cannot sue you, the institution, as individuals. But we can't get too comfortable about that because the Student Privacy Policy Office of the Federal Education Department could get involved. They could investigate a data breach if education records are released and could impose fines. So with that happy thought, I'm going to turn it back over to Shannon and Amber.
Great, thank you, Barbara. So let's talk about the data privacy law that really changed everything. So the European Union issued the General Data Protection Regulation, GDPR, in 2018. It became effective in 2018. They actually proposed the law in 2016 and gave institutions 2 years to comply. Of course, I would say that most institutions are probably not 100% compliant to this day. And the reason why is because the GDPR is comprehensive, it's complex, difficult to comply with, and it's extraterritorial in scope. So the European Union's General Data Protection Regulation establishes data privacy principles and fundamental rights for residents located in the EU. The law is extraterritorial in scope, meaning that you do not have to be located in the EU to be bound by the law. Instead, you have to be collecting or processing personal information of residents located in the EU, or you have to have brick and mortar in the EU. And so the question is, well, how does this apply to higher education institutions? And as many of you know, it does apply because you have prospective students and current students that are from the European Union. And when they submit applications, they're providing information to you while they're located over in the EU. You also have study abroad programs where you're sending students from the US into the EU for study abroad programs, often education programs. And you sometimes work with partner schools. So you have partnership agreements, and those are bound by GDPR. And because you're sharing the personal information of students and faculty, if they're there as well, you're often bound by GDPR. GDPR protects personal information, meaning anything that is really identifiable to an individual, and then also protects special categories of information. So a heightened standard of care really there when we're talking about special categories of information, that's things like race, ethnicity, religion, and more protected characteristics you would think of. Even if you are not established in the EU whatsoever, you may be bound by GDPR. And so it's important to have an understanding of this data privacy law. Next slide, please, Shannon. What GDPR does really when it comes into effect in 2018 is it sets the ground for consumers to have fundamental rights in relation to the data, and it requires entities that are subject to GDPR to have a lawful basis for processing data prior to collection of that data. What do I mean by that? So before you collect data from an individual, we call them a data subject in GDPR world, you have to have a lawful basis for processing. So you're not allowed, pursuant to the law, to be collecting information if you don't need it or don't have a justification to have it. When we're talking about general personal information and not that heightened standard of special categories I was discussing before, there are 6 basic lawful bases that you can apply. And so institutions can oftentimes ask for consent. So a student can provide consent before collecting information. Collection of student information is, of course, necessary for the legitimate interests of the higher education institution, in that in order to provide education services, we need certain information from students. And so we can often tailor data collection for student information into these 6 legal bases pretty easily. Where it gets more complicated is when you're collecting information, including that special category data that goes above and beyond something that might be necessary for a higher education institution. And so if that is the case, if we fall into the special category realm, which higher education institutions often do, because we want things like religious affiliation, racial or race or ethnicity in order to do things like report on diversity, we need to fall into a secondary category here, which is that we have to have an Article 9 lawful basis. And what that means is that we have to collect that information using something in this second tier here. We need to obtain explicit consent. So we have to inform the data subject of what we're collecting and why we're collecting it and where we may share it. Or it has to be necessary to the vital interests where consent is given, unless the data is made public by the data subject. And I could go on and on with hypotheticals. But what's important to note here is that institutions must have an enumerated lawful basis for collecting personal information from individuals located in the EU prior to collection. And so that means you have to have updated privacy policies, you have to have internal policies, and it seems like a very heavy lift, and it is. But what's important to note is most data privacy laws now follow this GDPR framework, and Shannon and I will talk about that as we work through this webinar. So if you're compliant with GDPR, you're oftentimes compliant with other data privacy laws. Next slide, Shannon. Pardon me. So what GDPR does is it establishes these fundamental rights for data subjects. So folks living in the EU have the right to make certain requests of institutions processing their personal information. Most of you have probably heard of some of these because they've become hot button topics, right? The right for an individual to request that you delete all of their data, or the right to access the information that you may have, or the right to object to an institution collecting or processing certain information. What's important to note is that although data subjects have these rights, they're not absolute. So institutions have the right to deny a request of a data subject or to partially comply with a request of a data subject. And so many higher education institutions I work with receive these requests, oftentimes from prospective students that have applied and most often been denied enrollment, or folks that are trying to pull back their information because they're receiving marketing communications. And so institutions have to respond. You have to respond to the data subject within 30 days of receiving the request. But that doesn't mean that you have to comply with the request. So that's very important to note, but individuals have these rights. Okay, next slide, Shannon. So what's really important to note when we're talking about GDPR, but privacy law in general, is what your responsibilities will be. So we talked about having a lawful basis for data collection, making sure that you're providing adequate notices and disclosures prior to collection. And then you're responsible for how you use the data. So where are you sending the data? Are you sending it to third-party service providers? Are you ensuring that those service providers are protecting the information as well? How long are you retaining data? Is it actually necessary for the purposes that you collected it, or are you keeping it forever? And so that's very important to note. Respecting individual rights, so those consumer rights that I was just talking about. If you have a data breach pursuant to GDPR, you have reporting obligations within the EU. So you have to report to a supervisory authority within 72 hours. And what I mean by that is the governing agency that enforces GDPR in each individual member state out of the EU. You also have data sharing and transferring responsibilities, and many of you have seen these when we start talking about technology vendor contracts, data processing addendum, data transfer agreements. Those all come into play because of GDPR. And so many of you, many higher education institutions actually have their own data protection addenda that they attach to any agreement with the vendor that they bring in. And so it's important to note that you have all of these compliance obligations in relation to GDPR. Next slide.
All right, so I'm going to talk a little bit about the Chinese Personal Information Protection Law, or PIPL. And this is a relatively new law. It came into effect at the end of 2021, although the way that this was rolled out by the Chinese government has been a little bit piecemeal. And so we're still kind of getting the regulations and things as they come and as they're released. It's very similar to GDPR in a lot of ways. It's a comprehensive data privacy law. And like GDPR, it's extraterritorial in scope, meaning it covers entities outside of China that handle the personal information of individuals within China's borders. So if you're collecting the information of Chinese nationals located within the geographic bounds of China, you're technically subject to this law. And as Amber mentioned with GDPR, this often comes into play for higher education institutions when you have to do with like admissions and recruitment of international students, or also study abroad programs. I can go to the next slide. We don't want to spend too much time on this because there is a lot of similarities to GDPR and just general privacy laws in general that Amber discussed when she was just talking about GDPR. But we did want to lay out some of the similarities and differences so far that we've been seeing between PIPL and GDPR. So similarities, some of which I've already mentioned, the extraterritorial scope of both of these laws, meaning even though you're located in the US, it might not have brick and mortar locations within China, you're still subject to this law if you're processing the information of individuals located within the geographic bounds of China. The definition of personal information and sensitive personal information are very similar. They have the distinction as well, meaning if you're processing race, ethnicity, sexual orientation, religion, things like that. That is considered sensitive personal information under the law. There's data breach reporting obligations, which is also seen under GDPR. Data impact assessments are a requirement under both the laws, and there also is lawful transfer mechanisms. So as Amber was talking about just a second ago with using DPAs for contracts with technology vendors, there's also going to be something very similar under the Chinese regime. They have a couple other lawful transfer mechanisms that we haven't seen under GDPR, but they are also drafting their version of a standard contract clause as well, which is probably what's going to be most likely relied upon by most higher education institutions. And then there's also the very similar individual rights that people whose data is being processed have, like the right to erasure, the right to know, things like that. And then some of the key differences: cross-border transfer based on adequate data protection. This, although it doesn't really necessarily apply to higher education institutions, but is worth noting to an extent. So the EU and US are working together right now on an adequacy decision, meaning that you won't have to use lawful transfer mechanisms anymore, like the standard contract clauses, to transfer data between the EU and the US. China's law doesn't contemplate this at all. They're not doing any sort of adequacy decision, meaning that you're always going to have to rely on a transfer mechanism. The next of kin have an ability to exercise the rights of deceased individuals. This is a little bit different. This is the biggest difference, probably, and the one of biggest note and concern for higher education institutions is there's personal liability for certain violations of the PIPL, meaning executives or decision makers can have personal liability as well as institutional liability for violations of PIPL. They also call for proactive deletion of information beyond just responding to erasure requests. And it's also more of a consent-driven law than GDPR. So, for example, with the lawful bases that Amber was discussing before, you have that legitimate interest legal basis that you can rely on under GDPR. Unfortunately, China did not include a legitimate interest legal basis for processing, and they call for consent a lot more often than the GDPR does. So meaning you need to obtain explicit consent from individuals located in China more than you likely do for individuals located in the EU.
Okay, we're going to transition here for a second and talk about cybersecurity mandates. So very important to note that many of the laws that higher education institutions are currently subject to are transforming in that they are now creating an enhanced cybersecurity mandate within the law. And so what we're seeing here under Gramm-Leach-Bliley Act, which comes into play for financial aid for higher education institutions, is the FTC promulgated new rules in relation to the safeguards rule and new requirements for higher education institutions. And this is a trend we're seeing for many laws, regulations, and rules that higher education institutions are subject to. So it's important to note that not only do you have to monitor new law, you need to review current law to make sure we don't have any kind of transition or new requirements in the cybersecurity realm. So the safeguards rule for Gramm-Leach-Bliley Act applies to post-secondary institutions or third-party service providers that process financial aid via Title IV programs via the Higher Education Act of 1965. And so what we saw was an update from the FTC mandating new cybersecurity measures for higher education institutions. Essentially, the FTC said this is sensitive information. Higher education institutions must protect this information. It addresses the confidentiality of the information that you hold in relation to financial institutions and financial information. If you're offering federal financial aid, you're likely bound by the safeguards rule here. The deadline for compliance was actually supposed to be December of last year. Shannon, correct me if I'm wrong here, but the FTC ended up extending the deadline for compliance because the new rules were complicated. And I think there was an understanding that it was difficult for higher education institutions to comply with some of the cybersecurity mandates I'll talk about in a second because of legacy systems and the decentralized solutions that Shannon was talking about earlier. Shannon, do you have anything to add there before we go to the next slide?
No, I think you covered it.
Okay, great. Okay, so here are some of the new rule requirements. This is a broad overview. We can go into much more detail if we need to, and happy to follow up on this. But here are some of the new cybersecurity rules that higher education institutions need to comply with. You must have an information security program, and the institution must implement and maintain that security program to ensure protection and security of customer information, financial aid information, financial information, to protect against threats and to prevent unauthorized access to that information. You must conduct risk assessments, and you must have adequate safeguards, administrative, physical, and technical safeguards, including multi-factor authentication, access controls, encryption in transit and at rest, having data retention policies, good data hygiene. All of that is now folded into the law. You have to designate a qualified individual to be responsible for overseeing and implementing the program. Now, this is difficult for some higher education institutions if you don't have a full force IT program or an individual to oversee. You now need to designate a qualified individual. And we know that providing information technology services is often difficult for some higher education institutions. And so this will place a burden on institutions that need to comply. You need to conduct security awareness training, which we recommend annually anyways, that your employees should have security awareness training, and you need to assess service providers. And so we'll talk about this in the next webinar, as Shannon mentioned, but you need to conduct diligence in relation to your service providers and what they're doing with the information you provide. Next slide. Shannon, I think this one's you.
Yep. So we just want to talk a sec about the New York Shield Act. This is also, it's kind of a two-part law. There's the breach notification side of the law, and then there's also the cybersecurity mandate side of the law. So the applicability of the law is very broad, kind of has a similar feel to some of the privacy laws we were talking about. So if you own or license personal information about New York residents, you're required to comply with the New York Shield Act. Owner license is kind of a weird way to phrase this, but basically what they're saying is if you collect the data and you're making decisions about it, they're kind of making, that's what they mean by ownership or license. So any higher education institution that either has a student from New York, even if you're not located in New York, or obviously if you're a New York college, you probably have New York students, you're going to be subject to this, or New York employees. And so on the data breach side of things, it basically talks about who needs to be notified, when, how, things like that. And it also outlines the definition of a data breach and what is considered private protected information. So New York data breach definition is very broad, one of the broadest in the country, since every single state, all 51 states and territories, have their own breach laws. So New York defines it as unauthorized access or acquisition of this information. And access is defined very broadly under the statute to include just viewing of the information. So if someone gets into your email account who's an unauthorized person and is just viewing things and not doing anything else, that is considered a breach under the New York Shield Act. And personal information is kind of what you think of generally in terms of protected information, things that people don't want public about themselves, such as your social security number, driver's license information, account information, biometric data, things like that. Then there's also the cybersecurity mandate side of things, which is kind of similar to like the safeguards, but not nearly as prescriptive. And it basically just calls for you to have appropriate administrative, technical, and physical safeguards in place to protect this private information. So there's also pending federal legislation. We won't spend too much time on this, but we thought it was something worth noting so that higher education institutions can start tracking it or paying attention to it. So it was introduced last May, and it has had pretty broad bipartisan support. It's structured very similarly to like the California Consumer Privacy Act or the General Data Protection Regulation in terms of providing privacy rights, having enforcement provisions through the FTC and state attorney generals, and also outlining certain security requirements. Unlike a lot of the state privacy laws that we're seeing that are being passed, this applies broadly to basically every type of institution or any type of business. So a lot of these past laws have exempted nonprofits or higher education institutions specifically. This federal legislation as it stands currently does not exempt higher education institutions or nonprofits, meaning that it will apply to higher ed if this does pass. And covered data is very broadly defined, like GDPR, and is anything that identifies or is linked or reasonably linkable to an individual. It's a very broad definition. It kind of stalled out. It had very broad support. Nancy Pelosi, when she was Speaker of the House, didn't want to bring it to the forefront because of the California Consumer Privacy Act. But now that she's not Speaker of the House anymore, it'll be interesting to see if this moves through the House or Senate at all.
Okay, I just wanted to give a brief overview on a few other areas of risk. I'm not going to go into too much detail on these, but a few other areas where we're seeing higher education questions in relation to cybersecurity and data privacy. So PCI DSS, if you're collecting or processing payment card information, there's been an update to the PCI DSS rules. There will be a PCI DSS version 4.0, which becomes you have to be compliant by March 31st, 2025. And so that was released last year. You have a couple of years to get compliant if you collect and process payment card information. ADA and website accessibility has recently been an issue for many clients in relation to their website. Similarly, privacy policies, terms of use, cookie pop-ups. So a lot more, we've seen a lot more issues in relation to your outward facing policies and your website. And many higher education institutions don't have comprehensive privacy policies, terms of use, or accessibility statements on their website, and they should. So that's an area of concern for higher education institutions. As Shannon just mentioned, higher ed institutions are bound by data breach statutes for all states. And so if you do have a data breach, you may have to report under multiple regimes. So in multi-state action, you may have to report under New York and Connecticut and Colorado and et cetera, et cetera. So it's important to note that as well. There are other international privacy laws. If we wanted to go over all of them, this would be probably a 10-hour webinar, and we don't want to do that to you. So it's important to note that if you have study abroad programs in other areas, in other countries like Brazil and Japan and Thailand and India and Australia, there are other data privacy laws to be concerned about. So it's important to note there. And then finally, we talked about this quickly, but if you have limited IT infrastructure or outdated systems, it makes compliance difficult. And so working towards a better infrastructure and updating your systems has become a priority for higher education institutions recently. And so if you can update those systems, it makes sense to do so. Next slide. Okay, so we're going to transition into the future risks section of the webinar. Barbara?
Thank you. So we've been talking about various areas within a college or university where data are stored. Another question that you may want to think about is who has access, which of your employees has access, and where are they? We have a number of employees working remotely now. Are they processing payroll information on their personal computer, for example? Are they using public Wi-Fi at a Starbucks or somewhere, working remotely with protected personal information, and a number of issues like that. We talked about training for employees. I think it's incredibly important, but the intersection of remote work and data privacy, I think, is something that some institutions may not have thought about and need to think carefully about. Next slide, please.
Okay, so we're just going to briefly touch on this because there's going to be an entire webinar on this topic of data breaches in higher education. We just want to reiterate how this is probably one of the biggest risks for a higher education institution to experience for a number of reasons. The first, as I kind of touched on before, higher education institutions are a prime target for bad actors looking to do nefarious things. According to Checkpoint Research 2022 survey report, education and research sector was the most attacked industry, averaging 1,600 weekly attacks, which was a 75% increase from their last study. And then not only are you a prime target, but data breaches are extremely costly. The average cost of a data breach in 2022 was $4.4 million, and this was based on an IBM study conducted in 2022. And an example of this from a higher education standpoint was a large university in 2020 confirmed that they had to pay a ransom payment of $1.14 million based on a ransomware attack to their School of Medicine. There's also a litigation risk. Data breach litigation and data privacy litigation is kind of a new area, but it's definitely emerging. Plaintiffs are getting very creative in the types of lawsuits that they're filing, even though there's not a prescribed private right of action under a lot of these laws. And for example, this was really only filed pretty recently. A small liberal arts college is facing a class action lawsuit due to a data breach experience that exposed over 63,000 individuals' personal information. So there's also not only the cost associated with the breach response itself, but there's now increased litigation risk as well. And then this is just a reminder, Amber touched on this when she was just speaking about higher education institutions having to report to multiple different agencies. So not only do you have multi-state reporting, but if it's financial information, you're also going to have your GLBA obligations. And then also you have your 24-hour notice requirements to the Department of Education as well. And then lastly, just a couple other risks we wanted to touch on. Responding to student record requests, the cybersecurity safeguards, which we've touched on a good amount, consumer data subject requests, data hygiene and retention, vendor management, and litigation and enforcement decisions. We've kind of touched on this throughout the presentation in general, but we kind of wanted to provide a summary slide of a high-level view of some of the other risks beyond a data breach that affect higher education institutions, just to kind of keep it in mind for people and kind of have it all synchronized in one place.
So a few things to know in closing. The state of the lay of the land, as we talked about, is constantly evolving. So the privacy laws that we discussed today and the cybersecurity mandates could change in a month or two. And we understand that that is daunting, but it's important to stay on top of it. And I think Barbara really described it well. This cybersecurity and data privacy really affect many departments and many areas for higher education institutions, just because of the amount of data you collect and what you use it for. And so our series is tailored to provide this primer today, kind of a high-level overview on applicable law and risks. And now the series will turn to risk mitigation and focusing in on strategy. So the next series will be on March 9th, the next webinar in the series, and that will talk about risk mitigation and vendor contract review. So those laws we talked about today, they create flow down obligations for your vendors. And so we'll talk about risk mitigation and how that affects vendor contract and vendor data processing. We will have a third part to the series, which discusses policies and procedures. So what Barbara was talking about with remote work and bring your own device policies and procedures you should have to mitigate risk internally for data privacy and cybersecurity. Part 4, we'll talk about data breach. So there will be a much more in-depth presentation in relation to how to respond to a data breach and potentially tabletop exercises for data breach response. Part 5 will tailor into marketing and admissions. Marketing and admissions data is highly regulated in relation to data privacy and cybersecurity, and how you use that data is very important. And then part 6, a very important topic, we will talk about cybersecurity insurance and why it is absolutely necessary for higher education institutions, and how to obtain it and some of the issues that come along with cybersecurity insurance. Next slide, please, Shannon. So I want to thank you all for joining today. Thank you, Barbara and Shannon, for presenting. If you have any questions, please feel free to send them along to us via the contacts you see here or in the chat, and we will follow up with you. Please feel free to fill out the survey after you close out. Thank you all so much.